Welcome everyone. This lecture will provide an overview of the foundation for legal rights for individuals under correctional control in the United States. We'll start off with reviewing four important constitutional amendments that have both historically and currently been the basis for examining the rights that individuals have when they're under correctional control. We'll also then take a broader look, step back, and just look at where do our rights come from as individuals in this country, and we'll take a look at those four foundations to make sure we're pretty comfortable with that. Then we'll dive back into a historical look at a policy that was roughly in place for 100 years throughout this country that really had a major impact on the rights of offenders, but also the way in which jails and prisons and the correctional system was run and how the courts handled it. Finally, we'll wrap up with a brief look at the prisoners' rights movement. Now, this was a movement that grew out of the civil rights era and also was a result of policies and court cases that sort of led to the end of the hands-off policy. The primary reading for this particular lecture will be Chapter 5 of your course textbook. So let's go ahead and get started. As mentioned on the previous slide, there are four key amendments in the U.S. Constitution that have played sort of a central role in the correctional system, and especially with respect to prisoners' rights. The first of these is the First Amendment. Now, the First Amendment, as we hopefully are somewhat familiar with, says that Congress shall make no law respecting an establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of people peacefully to assemble and to petition the government for a redress of grievances. Now, why is this relevant to the correctional system? Well, we could spend an entire semester talking about First Amendment and the role it's played throughout many different things, especially the correctional system in the United States. But as you go through and do your reading and listen to some of our upcoming lectures and even this lecture, I want you to pay close attention to how we have treated specifically religion. What religions are sort of allowed to be and respected for individuals under correctional control, especially when they're incarcerated? Are they able to practice freely? Are they able to have access to material? Also, abridging the freedom of speech or the press. Over time, we'll see that there have been changes in the type of literature and material that incarcerated individuals can even access or read, or in today's day and age, get access to electronically. And that's where I think the First Amendment in many ways is going to be sort of the backbone that we're going to be talking about in this course. Now, the next amendment that's going to be of key importance to us is the Fourth Amendment. And the Fourth Amendment is globally known, or generally known, as the right to be free from unreasonable searches and seizures of one's property. But as you can imagine, once somebody has even been detained by law enforcement, and then especially if they have been convicted of a crime and are serving a particular punishment, especially if they're incarcerated, we start to question and think about, well, do they still have the same rights as a free person who's walking the streets as far as having these Fourth Amendment rights? And one of the things, as I said with the last one, I want you to pay close attention to how Fourth Amendment rights have either been severely restricted or which types of rights are still free and available to individuals under correctional control. Then we have the Eighth Amendment. Now, the Eighth Amendment has sort of two key sides to it, which are both relevant to this course. One is something especially that's been rather relevant over the last few years with our sort of examination of the bail system in America. So the first part of the Eighth Amendment says that excessive bail shall not be required nor excessive fines imposed. And we'll talk about that a little bit more in detail in an upcoming lecture. But when we look at sort of the incarceration side, the Eighth Amendment is often referred to as the amendment that protects you from cruel and unusual punishment. And so as you're looking through the reading on this, I want you, especially with that area of being free from cruel and unusual punishment, how does a court determine that if a case is brought before them? What exactly are the key indicators of what exactly is cruel and unusual? And as I've mentioned, sort of like a broken record already, you'll notice court cases, the precedent, the legal sort of justifications have changed over time. So keep that in mind. finally, we have the 14th Amendment. And the 14th Amendment, one of the key components of it is the right to due process here in America. And one of the things that makes it relevant to the correctional system is, once again, is your right to due process, to have legal representation, to have a court case, to have a jury, to be able to present witnesses, to have, all these things that we think about in the classic sense of due process rights. At what point are those stripped away from individuals who are under correctional control? And at what point have they been sort of allocated the opportunity to have these 14th Amendment protections? Now that we've briefly reviewed 4 of the major amendments in the U.S. Constitution that have been sort of central to a lot of legal decision making and case precedent as far as individuals under correctional control, let's take a step back and make sure that we're all familiar with where do individuals in a country in the first place, such as the United States, where do we get our legal rights as citizens? And then this will also help us to talk about sort of the contrast between the rights of quote unquote free citizens versus the rights of individuals under correctional control who may have certain rights limited. So the largest and sort of the most overwhelming basis for legal rights for individuals are constitutions. They provide the primary foundation and description of what citizens under a particular jurisdiction that they have. They exist at both the state or the federal level. So we have our U.S. Constitution, which lays out a very global sense of rights for individuals, and then here in California, we also have a much more detailed and lengthy state constitution, which goes into describing our rights as citizens or members of this particular state. They also design within constitutions should lay out the basic design of government, and then dictate and describe our basic rights as citizens. Now, since constitutions are meant to be sort of like the top layer of, sort of like laying out the legal rights for individuals, oftentimes they're written in rather global or generic terms without having too much specificity. And this is where, as we start to see as we move on to the next couple slides, this is where other foundations of legal rights go into more of the minutia and the details of individual rights within specific situations and settings. The second major foundation for individuals' legal rights are statutes. Now, statutes are going to come from the legislative branch of government, and they are laws that are created by our elected officials, whether they be senators, assembly members, representatives. And the spirit of this is that by having these elected officials put into place by the voting populace, they should reflect what their constituents want and push for laws that value their constituency, but also value sort of the unique nature of, say, that individual state. And so that's why we start to see that statutes become much more specific than constitutions. And when you look across the United States, you'll notice the different types of laws that have been created by legislatures may differ drastically from one state to the next because of, one, the voting populace and their viewpoints, but also by who they chose to represent them in legislatures. So we see much more specificity in various places that can be vastly different in, say, California versus statutes in Wisconsin or Oklahoma or things of that nature. And then we have our third foundation, which is case law. And case law comes from that third branch of government, at least here in the United States, that judicial branch, where cases brought before a judge or jury and presented by attorneys help to create law, or oftentimes help to tweak and change and update law. And the spirit of case law comes from the ancient European tradition of common law. And these individual court decisions can not only create law, but they can change it. And as we'll see in the next few slides, especially with the hands-off policy, we'll see that it was actually case law that really was a driving force to sort of change the viewpoint and change the laws to better reflect sort of changing times and the viewpoints of different generations of citizenry. And what happens when these court decisions create law, it becomes known as precedent. And it's known as precedent in the sense that maybe in future court cases, the attorneys or the judges can refer back to previous cases in order to sort of base their new foundations on whether they want to stick with that precedent and keep the law similar in spirit, or whether there's a legal foundation or a constitutional foundation, which reason for why they can deviate from that precedent. And finally, the fourth foundation of legal rights are regulations. Now, regulations are a very, very, very broad area of law, and maybe one of the reasons for that is because these are rules made by administrative agencies. And if you think about all the administrative agencies, whether it's at the state level, the county level, or the city level, oftentimes these rules are very specific to sort of whatever the functions and focuses or foci of those agencies. And as you can see here, they typically are meant to guide sort of administrative and institutional behavior in very specific settings. Now we're going to shift gears a bit and go on a bit of a historical journey to look at something known as the hands-off policy. Now, this was an unofficial policy that really dominated a lot of legal thinking for about 100 years here in America. And it really dictated how courts across the land and how judges throughout those courts treated and responded to cases involving individuals under correctional control, especially individuals who were under some form of incarceration. Now, this thing called the hands-off policy started with a case that made its way to the U.S. Supreme Court in 1871 out of Virginia. The case was Ruffin v. Commonwealth. And the key finding that the justices sort of presented was this, what you see here in yellow, and it's a bit paraphrased. But the takeaway was this: a prisoner has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those for which the law in its humanity accords to him. He is for the time being the slave of the state. This became very heavy language that, as I said, sort of started a push, a change of how individuals under correctional control would be handled by courts throughout the land for roughly 100 years. And let's take a look at a couple of the key things. So they're saying that because you've been convicted of a crime, you have not only lost your liberty, meaning we can lock you up, we can punish you, but we're also stripping all of your personal rights. So we're not even going to treat you as a citizen of this country while you're under correctional control. That's really heavy language. And then to wrap up the statement, they try to drive it in even to be more clear. He is for the time being the slave of the state. This was referred to as the hands-off. Why did they call it the hands-off? Well, after Ruffin v. Commonwealth, courts across the United States either refused to hear prisoners' rights cases at all, or in many of those courts where the judges decided to hear the cases, they decided those cases in a way that sent a message of you have no rights because you are an individual under correctional control. And you can imagine how that's the idea of like, so it's hands off. We don't want anything to do with you. If you're a prisoner, then we don't even want to treat you as a citizen, and don't come to us claiming that you have, cruel and unusual punishment, that you don't have access to certain forms of press or media. Don't come to us complaining about, your opportunity to practice a religion or to have different types of food, or that you're being held against your will. They pretty much said you are dead to us in many ways. And in fact, in California, the approach and sort of the general sort of language that we think about it during that time period was to refer to this period as civil death in California. An individual was seen as being civilly dead. And even though we're going to see on the next couple slides how this hands-off policy has been stripped back and pretty much come to an end in many ways, it still has remnants of it. During this time period, during the late 1800s through a good portion of the 1900s, individuals who were incarcerated in many ways had little or no rights that they could bring forth before a court. And this idea of civil death in California, so this might mean the idea of invalidating a marriage. This may be the idea of stripping property from somebody. It may be, taking, I just said stripping property, so taking land from them or businesses from them, voting rights. And many of these things during that time period, especially even once you were released from incarceration and had served your time, you didn't get back a lot of those liberties, those rights. And even in today's day and age, there are still remnants of that where people either have to petition to have certain rights sort of returned to them, or they have to wait a certain amount of time before they get those rights back. Roughly 100 years after Ruffin v. Commonwealth and the beginning of the hands-off policy, which started at the U.S. Supreme Court at the federal level and then spread all across the United States, we start to see the end of this particular policy. And we definitely see the major manifestations of sort of chipping away at the policy in a handful of cases that occurred in the 1960s and the early 1970s. And two of them I'm going to sort of focus on for the sake of this class. One was Cooper v. Pate in 1964, a case out of Illinois. And in this case, the U.S. Supreme Court made reference back to the Civil Rights Act of 1871. Now, the Civil Rights Act of 1871 was largely in response to the Ku Klux Klan and their abuses of power in many of the southern states. And so a lot of legal scholars would argue that multiple sections of this quote-unquote Civil Rights Act were not giving any rights to anybody, but actually giving means in which individuals could ask for the enforcement of rights that they should have already had. And one particular section of the Civil Rights Act, Section 1983, is what became pertinent to this hands-off policy. And what this did in this case is the U.S. Supreme Court, by referencing the Civil Rights Act of 1871 and specifically Section 1983, they announced that prisoners had rights guaranteed by the U.S. Constitution, and they could ask the judicial system for help in challenging the conditions of their imprisonment. Now, their conditions of imprisonment and what their challenges were pretty broad. I mean, there wasn't necessarily set. But what you can see here is they're referring back to the U.S. Constitution, the highest law of the land. And as you can also see here, it doesn't guarantee that those individuals are going to have their rights represented or actually, appreciated, but rather it gives them the opportunity to at least ask the judicial system for help. So we see that's what they often refer to as sort of the ends of the hands off. As we're saying with Cooper v. Pate, the courts can no longer just refer to the hands-off policy or doctrines that came after it as a reason for not even hearing or considering a particular case. So rather it started breaking down the door for individuals to start to ask for the courts to recognize and at least consider their conditions and when they thought that their rights were being violated. We also had a few years or a decade later, Wolf v. McDonnell. And Wolf v. McDonnell, one of the key takeaways from this one is that it allowed due process rights for prison inmates whenever disciplinary decisions were being made, right? So whereas the larger sense, somebody may be sentenced to prison and it may not have the best food or the best access to reading material, or it may not be the most comfortable place. But a whole nother layer of that is if you're having an extra level of discipline handed down upon you as opposed to what was part of your initial sentence. And so what Wolf v. McDonnell did is it allowed inmates the right to say, hey, wait, hold on. If you're going to discipline me for something that I have done during my time in prison, I should then have the opportunity to have certain due process rights before you just arbitrarily change the level of discipline that I'm facing within this prison. The end of the hands-off policy that began with cases like Cooper and Wolf in the 1960s and 1970s really led to a dramatic shift in how courts started to recognize and respect and respond to cases involving prisoners' rights. And there's quite a few outgrowths that we could go through, but I'm just going to highlight a few. One, probably one of the largest things we saw was a major increase in the use of habeas corpus. And habeas corpus, going back to its Latin origin, refers to the argument of may you have the body. And what this allowed offenders to do and prisoners to do was to file a writ of habeas corpus and asking the court to examine the legality of some component of their confinement. And oftentimes, the component of confinement that they wanted to have examined and questioned by the courts referred back to what they thought or argued was a basic right guaranteed by the U.S. Constitution under amendments like the First Amendment, the Fourth Amendment, the Eighth Amendment, and the 14th Amendment. So we started to see the use of writs of habeas corpus to have individuals ask for courts to consider whether or not their right to religion was being infringed, whether or not the way that they were searched or had material taken from them, even in the cells in the prison, whether or not that violated their Fourth Amendment rights, whether or not the conditions of their confinement violated their Eighth Amendment rights, and things of that nature. In California, this sort of the end of the hands-off policy was really sort of, codified under California's Penal Code 2600. And this became known as the Convict Bill of Rights. It was a way of stripping away that old civil death and the hands-off policy that we had seen in California, and it started to recognize the fact that individuals under correctional control should have Bill of Rights, and sometimes they may not have all the freedoms and liberty of a free citizen, but started to recognize when the courts had overstepped or when our correctional system had overstepped and infringed upon their rights in the past. And this led to the prisoners' rights movement. So that sort of corresponding with the civil rights movement of the late 1960s and the 1970s in America, we see the end of this hands-off policy, the creation of things like the Convict Bill of Rights, the use of habeas corpus to really start examining and forcing courts to consider the environment and conditions that inmates were living within. And this prisoners' rights movement had quite a few outgrowths, but we'll wrap up this particular lecture today just sort of listing some of the key changes that occurred during that time period. So one of the first things that we started to see an effect of the prisoners' rights movement was that it opened lines of previously censored communication between prisoners, public officials, and news media. So it sounds kind of simple, but this right to sort of have access to your own reading material, to communicate with other individuals both in and out of prison, that had largely been censored and shut down for roughly 100 years during the whole hands-off policy, and courts wouldn't speak up or protect the rights of inmates who wanted to reach out to communicate with attorneys, to share their story with the news media, to tell their stories to their elected officials, or to get access to certain types of reading material. These lines started to be open, and you can imagine once we started stripping back that black box of the correctional system, all of a sudden the public started to see what was really going on in certain places and the ways in which the rights of offenders were being infringed upon. And of course, this led to investigation of how court systems worked, how prison system worked, scandals about what was really going on behind the brick walls of prisons. Also, it led to a second sort of major effect was we saw the growth of convict political activism. Now that inmates could get access to reading material, news material, legal material, they could become jailhouse lawyers. They could start to realize how their rights were being infringed upon, look at case law, look at the precedent, and then be able to share that in order to fight for their own rights, as opposed to being sort of left on their own with no sort of connection to the outside world. And this also started to have inmates and offenders start to band together. They had a cause, a movement started to come out of this, as far as it's not just my rights are being infringed upon, but maybe it's an entire segment of offenders that are having their rights, certain religions, certain backgrounds. And we'll talk later, one of the things that you could definitely see a direct connection with was we started to see the growth of certain prison gangs. Now, when we say prison gangs, we think, ooh, that's not a good thing. But as we'll talk about later in that lecture, one of the things we notice is sometimes prison gangs didn't form with sort of malice or, a sense of violence. Rather, it was because they wanted their rights heard. And we'll talk more about that when we get there. And this also led to, prisoners were able to come together, reading, writing, study groups, so that they became more educated. They started to look outside of the world that they had been living in. Just using California as an example, 1978, ex-prisoners were finally returned the right to vote. So we started to see, once again, even after the hands-off policy was starting to die off, there was still a lot of remnants about people's, the things that had been stripped away from somebody for getting, a felony conviction. We also saw changes in the effects of prison discipline. Now, sadly, as we started to see activism and sort of access to the outside world and the recognition of scandals and, discretion in how the various prisons were run, all of a sudden you can see that started to lead to unrest on both sides of the table. And so an unfortunate outcome of it was an increase in the number of attacks on guards. Inmates started to band together and started to feel like they had more control, and that sort of weakened the ability of the staff and the management to handle the inmates. But then they quickly responded with further changes to how the prisons were run in the first place. And one of the things we saw, so sort of in response to increased attacks on guards by inmates, we started to see a sharper focus on how we sort of housed and separated and sort of treated various individuals, various offenders. And one of these was the use of what are known as special restrictive yards. In California, we often refer to this as maximum security administrative segregation, or ADSEG. And the spirit of this was, oftentimes it wasn't necessarily to lock up the most dangerous person, but rather it was to lock up the shot callers, the people who could rally other inmates, the people who could, get movement started. And we see what we started to see were these things called secure housing units, often known as SHUs, as an acronym. The first one started popping up at Pelican Bay up in Northern California, and these were separate blocks or regions or cells of the actual prisons to house these quote-unquote troublemakers. Now, yes, sometimes it was the most violent offenders who could do harm not just to guards but also other inmates, but also there was a big focus on using these secure housing units to separate some of the most powerful inmates from the larger sort of population of inmates, and in order to further isolate them within these under maximum security administrative segregation or secure housing units, which all sound sort of politically nice, we start to understand that now, looking back, was the growth of the use of solitary confinement, right? If you really want to segregate somebody, you got to lock them up by themselves. Don't let them have access of or communication with the other inmates. And so we started to see this growth of solitary confinement. And in my mind, I think of it almost as a throwback to the penitentiary model. And then this spread on to how we have responded. And even today, we're still starting to understand the impact that this has had on generations of offenders as far as the impact of solitary confinement, the impact of separating them not just within a prison, but sending them to certain prisons that have, certain ADSEG or SHU units that are maybe even further away from their family and their community that they're eventually going to return to. And so there's been a lot of things that we'll continue to examine as we go forward. But I'll leave it there. There's sort of hitting some of the highlights with what we've seen as far as the foundation for prisoners' rights and sort of the change that we've seen in America, at least since the 1870s up until the late 70s, late 1970s, and into the 1980s. All right, we'll leave it there. Have a good day.